We have a question by Pat. Pat says, we sold our house and the transfer went through on the 18th of August. We received a call on the 25th of August, so a few days later, saying that the geyser is leaking and that we have to get it repaired or replaced. Pat says, I want to do the right thing, but I'm not sure where I stand legally. Bruno, please can we give Pat some advice here?
Sure. So unfortunately, the question doesn't have a lot of detail. So I'd love to know what the right thing versus the wrong thing is. Because my interpretation of this would be, or at least if I put myself in his shoes and start thinking, why would I be asking a lawyer a question? It would probably be around when the damage actually did take place. So now all of a sudden transfer's taken place and amazingly, the geyser's leaking. And it's very convenient because the seller goes, oh, well, it wasn't on my watch, so sorry, it's your responsibility. And things like that seem to be very convenient. Sorry, air marks, convenient. And I've got a very similar case now, also along the same terms, except it was more serious. So it was with respect to vandalism. And the property was transferred on the one day, I think the Tuesday, and Tuesday night, they got a phone call from the neighbor. They're saying, oh, by the way, it looks like the property is being vandalized. And the neighbor called the attorneys, and the attorneys let my client, the purchaser, know that the property is being vandalized. But the neighbor didn't see vandals at that moment. There was nothing to say that it was vandalized on the specific day or after transfer. So maybe so that's just context. These are the facts that I'm working within. So for the sake of this question, this is how I understand the question being asked from Pat. So taking a step back, when are we responsible? Who's responsible for what? When a property sells, typically private sale, there's a risk clause in there that says that on date of registration, risk passes to the purchaser. This can be deviated from and often is in sales and execution, or for example, if a purchaser takes early occupation, right? But judging from the sounds of it, Pat would have known about the leaking geyser if he was in early occupation. So I'm going to assume that it was a normal contract and that he took risk after the property was transferred. If that's the case, strictly speaking, comes down to facts. When did the geyser start leaking? Now, you need to remember that insurances typically cover this. So we also shouldn't, it's not to say that insurances will cover it, so don't worry about it. But at some point or another, it's either the seller's insurance that would cover it or your insurance that would cover it. So before taking it too far and getting into any sort of altercation with the seller, just remember that it's really just a matter of agreeing like who it was, submitting the claim, and then letting the insurers fight it out potentially, right? So that's normally what it comes down to. But the reality is, if you weren't insured, because like, for example, with my client, the issue is the insurance only kicked in 2 days after transfer. So if they were responsible on the day of transfer, they weren't actually insured. And that started becoming problematic. So if that's the case and you have to fight about it, the reality is it comes down to facts. When would the geyser have started leaking? And look, I'm not an expert in this, but I would probably say best thing to do is sooner rather than later, get someone there just to see if there's stains or if there's damage, long-term damage. Because if you see that there's stains that are, that started causing rot or whatever the case is, like on ceiling boards specifically, if they start swelling, they might be able to say, no, this is a lot older than a couple of days. This was definitely leaking before. If it seemed pretty fresh, you might be in a difficult situation because you're kind of on the offensive here. And then maybe just go to your insurer and go, well, look, it looks like it was on this date. Please pay out the claim.
Thanks, Bruno. I'm going to move on to the next question. And it may sound like a very obvious question to a lot of our viewers, especially those who have been in, the property game and investing in properties and selling and, purchasing properties. But for a lot of people out there who maybe their first time, this is a real concern. So Cilna, the viewer wants to know, says, we sold our property Now the lawyers have told us that we have to pay 3 months lights and rates in advance. She wants to know, is this the normal practice? She says the lawyers mentioned that the buyer also has to pay 3 months lights and rates in advance, and that we will be reimbursed for the money paid. She wants to know, is this correct? And shouldn't the value that we're going to pay, the 3 months, shouldn't it come out of the sale money?
It's actually such a good question, Chris, and I really love the fact that we're getting these kind of questions. I mean, that's why we're here, to keep it, you know, practical daily buying, selling, renting, whatever. And the truth is, this is very standard practice. So the reason for this is you need to, as the seller, so you're the owner of the property and you are responsible for payment of rates and taxes and utilities up to the point of transfer. That's in terms of most of the bylaws in South Africa. This is standard issue. Up to the point of transfer, you are responsible for payment of rates, taxes, utilities. From the moment of transfer, this is now the responsibility of the purchaser, who will be the new owner of the property. So when we request clearance certificates from the municipality, it's usually the municipality that requests 3 months payment of utilities, rates and taxes, and it's a bit of a ballpark figure. It's an average of the normal expense that you would have on a property, rates and taxes, and the municipality requests that 3 months clearance figure to issue your clearance certificate. This is also the reason why your clearance certificate is only valid for a limited time period. So that your clearance certificate will always have an end date. And the moment you pass that date, unfortunately, you have to obtain a new clearance certificate. And in most instances, the municipality will then require a further 3 months average payment for your average rates and taxes and utilities. The reason why the conveyancers would ask for 3 months rates and taxes and utilities from the purchaser is, I must say, that's not, 3 months might be a little more than what you would normally see in transfers. It's normally less than that, because up to the point of transfer, the seller is liable, and it's that time period that's unpredictable. And from the moment of transfer, it becomes the responsibility of the purchaser. So the 3 months for the purchaser sounds a little less standard practice. I don't see anything wrong with it. It doesn't, you know, raise my concern sort of vibe there. But it's not that standard. Seller, 3 months standard, very standard, and that's not the conveyancers, that's the municipality asking for that. And how it works is, when you get to the point of transfer, your conveyancer must then do the mathematics, and you will see on your final statement from the conveyancers, they will then reflect purchase price, proceeds, the whole thing, rates and taxes, utilities, occupational rent, whatever the case might be. It will be clearly reflected, and the seller will be refunded together with the proceeds. The reason why they can't just take that from the proceeds is because the municipality requests that in advance to issue the clearance certificate. And unfortunately, for a conveyancer to pay that money over to the municipality on behalf of the seller, unless the conveyancer is very nice and paying it from their business account, to pay it from your trust account is obviously stealing trust money. And that's bad, and you will go to jail, which is not pleasant for anybody. So it's very standard practice for a seller to pay that 3 months in advance for the clearance certificate. Purchaser, like I said, not that average, but it wouldn't raise too many concerns for me. Even that wouldn't raise concerns for me.
Thanks, Cilna.